Alrighty, hi guys. This is a Clean Water Act project. My name's Ikstan.
I'm Benjamin Connolly.
I'm Brianna. I'm Cassandra Takum.
And we're gonna go ahead and just talk about the Clean Water Act and how it came to be and some other really good information.
So the Clean Water Act was enacted in 1948 as the Federal Water Pollution Control Act. And then in 1972, the act was significantly reorganized and expanded into the Clean Water Act. It is to protect human health, ecological resources, and to maintain healthy waters and restore what has been impacted in any way due to pollution or other things that have entered the water system. There are tools and guidance from states and authorized tribes to help protect the water with corporations, with the help of federal government agencies. And the purpose of the Clean Water Act is to restore and maintain chemical, physical, biological integrity of the nation's waters. Under the Clean Water Act, the EPA, the Environmental Protection Agency, has implemented pollution control programs like watershed standards for industries. The EPA has also developed national water quality criteria recommendations for pollution in the surface of water. And there's also certain waters that does not, the Clean Water Act does not directly address groundwater contamination. And we will be talking about other ways that the Clean Water Act helps protect our water for the future and for now. Next. This is a video that is just like a little quick summary of the act and why it is put into place.
In the summer of 1969, sparks from a passing train showered down upon a portion of the Cuyahoga River in Cleveland, Ohio. Rather than dissipating into the water as expected, the sparks ignited pollutants floating on the surface and set the river on fire. And not for the first time. This portion of the Cuyahoga River was heavily populated by industrial facilities that dumped waste directly into the water. The river caught fire so often that locals barely even took notice any longer. They simply put out the blaze and carried on as if nothing out of the ordinary had happened at all. The burning of the Cuyahoga River was not the only environmental disaster caused by unregulated dumping into our nation's waters, but the publicity of the event finally drew the public eye to the issue. Federal lawmakers took action by passing the Federal Water Pollution Control Act amendments of 1972, now commonly known as the Clean Water Act. Today, the Clean Water Act protects the quality of America's waters through direct regulation of water pollutants and their points of origin. The Clean Water Act prevents direct discharges of pollutants into the waters of the United States through a program known as the National Pollutant Discharge Elimination System, NPDES. The program has very strict requirements, but it only applies to certain types of water pollution. The program regulates only point sources of pollution, which means that pollutants must be carried to the water body by an individual and direct conveyance, such as a pipe or storm drain. Pollution aggregated over a large space, such as agricultural runoff, is not regulated by the Clean Water Act. Furthermore, the pollutant being discharged through the point source must reach navigable waters, meaning that the polluted water body must directly connect to larger rivers, lakes, and oceans used for shipping and commerce. Groundwater and water bodies unconnected to our nation's larger surface waters, such as backyard ponds or drainable ditches, are protected by other statutes and not subject to Clean Water Act jurisdiction. Congress limited NPDES jurisdiction by defining the types of polluters and affected waters covered by the program. However, the law allows substantial latitude with respect to the nature or type of regulated pollutants. No matter how harmless they may be, all substances discharged into America's surface waters by means of point sources are covered under the NPDES program. Those subject to NPDES regulations must apply for and receive a permit that authorizes the discharge of water pollution under very strict standards and in specifically limited amounts. Failure to comply with the terms of an NPDES permit or any other Clean Water Act requirement can give rise to civil or criminal liability. Any violation of the Clean Water Act, such as by discharging water pollution without a permit or by exceeding pollution levels authorized by an existing permit, gives rise to a potential penalty of up to $32,500 per violation per day. Knowing or intentional violation of the Clean Water Act is a crime, carrying with it a possible sentence of 15 years in federal prison. Like many environmental programs, the Environmental Protection Agency was initially charged with the enforcement of the NPDES program and other Clean Water Act requirements, but state governments may opt to administer and enforce NPDES requirements within their borders. The Clean Water Act in the summer of 1969.
So the intent of this legislation, the Clean Water Act, was created to prevent harm and any contamination to our marine environment, which includes above and below ground water sources. Our marine environment holds aesthetic, recreational, and economic value that needs protection. And to overall summarize, the legislation was created to regulate the quality of our waters to its truest nature, and which includes maintaining its chemical, physical, and biological state. And in the image as well, you could see that the clean water is like necessary in our daily lives. Many people use it for recreational use, such as paddleboarding, kayaking, and stuff like that. And it's essential to have clean water in order to not get sick and other issues. Next slide.
I just realized I was muted this whole time. Anyway, so the legislative history for the Clean Water Act, it started in 1948 as the Federal Water Pollution Control Act. And this was created to set the concept, to basically set the comprehensive water control quality programs and to start the financing for state and local governments. This was later amended in 1972, and this changed and rewritten a few things, like establishing structure for regulating pollutants. It gave the EPA authority to make pollution control programs, which we'll go over later, and kept existing requirements for water quality standards for contaminants in surface water. It also made it unlawful to dump pollutants in any waterways without a permit. It funded construction of sewage treatment plants, which is very important. And it showed it necessary for planning. It made it necessary for planning against problems to get ahead of the problem before the pollution happened. Later there were some subsequent amendments or revisions. In 1981, they had the streamlined municipal construction grant process, and then later that was changed and replacing it with the State Water Pollution Control Revolving Fund, which was in 1987. In 2015, they had a rule of definition, which basically everyone was wondering what exactly is can this Clean Water Act touch upon. It's something that's still in the works today, but it affected the water that falls under Section 404 of the Clean Water Act, and federal courts and agencies basically wanted to change the focus of what it actually affects to, what kind of waterways will be in tow. Next.
So through the congressional power to pass the Clean Water Act, Congress was able to pass the Clean Water Act through the Commerce Clause due to it relating to interstate commerce. Congress establishes the EPA to help set goals on what is allowed on navigable waters and not regulations. And I feel like that's key in order to understand that the EPA is there to establish goals and not to regulate. Having bodies of water that are navigable in the having bodies of water that are navigable in the act grants Congress access to regulate and pass legislations. And on the following slide, we're going to see examples of non-navigable waters. This list comes from the US EPA website. And it overall states the list covers certain artificial irrigated areas that are not covered as non-navigable waters, as well as horticulture and roadside ditches and artificial lakes and or ponds. And on the other picture, you could see what is considered unprotected and protective navigable waters.
All right, gonna take myself off mute this time. So we have our enforcement mechanisms. So the Environmental Protection Agency works with different regulatory partners, but all of it really falls under the National Pollution Discharge Elimination System and NPDES. And basically the California Water Act only affects direct water sources such as pipe or storm drains, or like rivers or any basically any municipal waters. And so those permits, they affect different, like I said, they have the different regulatory partners, and those are sanitary sewer systems and combined sewer systems, national pretreatment programs, stormwater pollution prevention plans, the discharge for concentrated animal feeding operations, biosolids, and oil spill and spillover prevention. With stormwater, or with the sanitary sewer systems and combined sewer systems, basically they go through a process. If there is something wrong, any kind of pollutants going in, they have to go through inspections. And so this is kind of like to get ahead of the problem before it happens. So they have to review the permits and enforce any orders that are made. They have to verify the permits. They have a bunch of CSO control plans that they have to follow. And they just implement all these programs for each of these different things. And then they have to go over the overflows in the sensitive areas, making sure that it's like not clogged or anything, nothing's inside these drains. So they're basically just trying to minimize industrial discharges. And then we have the pre-treatment side. So things that are going against this it's almost the same thing. They review programs that are already established, reports. They go through compliance like documentation and inspections and files, and they'll even go through like citizen complaints if there is something not right. So maybe there's a smell in the air, and a customer can complain, write that down, and they can use that in their process when it comes to enforcing these rules. They'll interview officials, and they'll even test of the workers. They'll make sure that they're doing their stuff right, making sure they have all their certifications to make sure that they're running everything right. The same thing could really go for stormwater pollution prevention plan. It's the same basic structure. There's also our animal feeding operations. And it's basically they have to, make sure that they're keeping up with the discharge areas, making sure they have permits to discharge from this. This includes like animal waste, for example. It's all permutations, records, and reports, making sure that everything's documented so that they can say that, you know, it's falling under the permit. So it's just a lot of paperwork, things to keep up on. Same goes for the biosolids as well, making sure that all the sludge that's coming off of the treatment plant, that's probably getting disputed, or sorry, not disputed, properly, you know, thrown out. They also do sampling to make sure how much of that nasty stuff is actually in there. Samples are a really big thing when it comes to biosolids, or even the pre-treatment plants. Everything, like I said, it's all documentation. All samples is part of that documentation process. And then they also go over oil spills and spill prevention. So most of it's spill prevention, but we've seen the big oil spills, how they affect the water, especially like in our oceans and whatnot. But it's just, like I said, it's just going over all the plans, making sure that they're following protocol, and just basically going by the book. All right. Next slide.
So this case study is Rapanos versus the United States. It was done in 2006. So basically, the rule is that the United States Army Corps of Engineers stated that all interest wetlands and all other waters such as interstate lakes, rivers, streams, mudflats, sandflats, wetlands, prairie potholes, wet meadows, playa lakes, or natural ponds and adjacent waters are regulated under the Clean Water Act. The problem with this is that although it does state like very specific water, I guess water bodies of water, the last part of having adjacent waters, that's very, very vague. So it could literally just be like a wetland that overflows like once a year, or it could be a wetland that's in somebody's private property. In this case, that part of the fact is that the Clean Water Act made it unlawful to discharge fill material into any navigable water without a permit. In this case, John A. Rapanos was sued by the U.S. Because he had deposited full material into a wetland on his property without a permit. The federal district court and the federal appeal court, they found that the wetlands in question were within the federal jurisdiction because they were adjacent to other waters. So his particular land, they stated that when it overflowed or when it was actually full, it would actually run into another body of water outside of his property. But he claimed that that wasn't the case, that those wetlands had been filled prior to him buying the property, and by the state of Michigan, because he bought the property from the state of Michigan. So prior to him purchasing it, that had already been filled, and there was no more wetlands where he put more items into them. So the issue was, did the appeal court employ the correct clean water analysis in both cases? And the Supreme Court said no. So basically what the Supreme Court said, that that kind of set precedent that the phrase "the waters of the U.S." included only relatively permanent, standing, or continuously flowing bodies of water. So example, like streams, oceans, rivers, and lakes, and that the phrase did not include channels that periodically provide drainage for rainfall. So this kind of took away the adjacent waters that are regulated, that it was stated under the Clean Water Act. So in this case, it kind of just set precedent to no longer consider like private property wetlands, or like ponds on private property that don't drain into like a big body of water, or not there year round. So that case was pretty important. And then this is actually more current. This actually was from last year. I did not put the year on there, but it's from last year. It was ruled on April 2020. So basically, this is the County of Maui versus the Hawaiian Wildlife Fund. So once again, we see that companies need to go ahead and have some sort of permit to be able to go ahead and add any pollutants to the water. So in this case, the Clean Water Act forbids the addition of any pollutants from any point source to navigable waters without appropriate permit from the EPA. The fact is that County of Maui's water waste reclamation facility collects sewage from the surrounding area, partially treats it, and pumps around 4 million gallons of treated water into the ground through 4 wells. So eventually this partially treated water travels from the groundwater to the ocean, and the environmental groups sued them, alleging that Maui was discharging pollutants to navigable waters without the required permit. Once again, the district court in the Ninth Circuit Court found that the discharge into nearby groundwater was functionally was basically running into the water, and pled in favor of the environmentalist group. Once the Supreme Court took it up, the issue was that the Ninth Court interpretation of the CWA that the permitting requirement applies as long as the pollutant is fairly treatable to the point source, even if it traveled through groundwater before it reached navigable waters. So basically the environmentalists said, hey, as long as we can go ahead and prove that this pollutant came from this particular place, even though it traveled to go ahead and get there, then they're responsible. And the company said, well, according to the law, it states that it has to be from the point source for us to have to need a permit. So the Supreme Court said that, yeah, the Ninth Circuit interpretation was incorrect. So in conclusion, due to the differences of standards adopted to the different courts of appeal, the Supreme Court of the United States granted Maui's petition to review the question whether the CWA requires an EPA permit when pollutants originate from a point source but are conveyed to navigable waters by a non-point source. The Supreme Court actually put like an equation in place for this particular matter, which they call the functional equivalence. It states that if the discharge is the functional equivalent or direct discharge to navigable waters, then you need a permit. So like you need to be able to have both. You need to be able to have like prove that this amount of discharge, like in this case, it's 4 million gallons, is directly going to the water source, and have like, it has to be equal to whatever they're discharging to whatever the water source goes. So in this case, the Supreme Court kind of did something in the middle, where they didn't necessarily disagree with either party. What they just said, it was like, for environmentalists, your definition is too broad, and for the companies, your definition is too narrow. So they kind of just went like halfway. And this is going to go ahead and impact other companies when they said, hey, like the pollutants over there, but we're over here. So as long as we're not, like all of our pollutant isn't going to the body of water, then we don't need a permit.
All right, so for our Clean Water Act quiz, the first question was, what kind of procedure does NPDES permits not enact when it comes to pollutants? Is it A, pulling up records, reports, or audits? B, interviewing employees on education or work? C, rewriting plans to accommodate pollutants? Or D, taking water samples? Answers on the next page. Number 2, what was a change in the CWA during the 1972 amendment? Was it A, streamlined the municipal construction grant process? B, made it lawful to dump pollutants into waterways? C, phased out construction grant process? Or D, funded construction of sewage treatment plants? Answer is on the next page. Oh, sorry, it's not even the next page. It's the page after the next page. Number 3, what is the example of the navigable waters? A, artificial lake or pond. B, water-filled depression made from construction. C, Mississippi River. Or D, the big swimming pool you always wanted.
This is like the rest of the quiz, 2 more questions. These are going to be true or false. Number 4, the Environmental Protection Agency was created in 1970, true or false. And then John A. Rano sued the US for filling wetlands on his property, true or false? And these are the answers. And these are their references, and I think we are done. Thanks for listening, guys. Have a good day.